recording, obviously, except this time, you're seeing it instead of me. And I also decided to kind of show this through some slides, what we're going to talk about, and the topic obviously being the First Amendment and World War One. All right, so the First Amendment of the U.S. Constitution states that Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. So in simple terms, the First Amendment protects 5 freedoms: the freedom of speech, the freedom of religion, freedom of the press, freedom of assembly, and the right to petition. So the First Amendment obviously is drafted with the Constitution, but in order to understand troubles with this amendment and troubles with amendments in general, because no amendment is free from scrutiny, we have to go way, way back. And what I mean by that is obviously touching first upon John Adams and the Alien and Sedition Acts, right, which came out around 1798. These acts are implemented due to anti-French sentiments that follow the XYZ affair. If you recall, the XYZ affair was basically saying when France tried to extort ambassadors and representatives from the United States, right, for favor. This caused that rift between Federalists and Democratic Republicans. And during this time in office, you have John Adams, a fairly unpopular Federalist president at the time. Well, let's focus on the Sedition Acts, right? The Sedition Act itself set fines and jail terms for anyone who, would spread false, scandalous, and malicious statements against the government. Basically, you get in the way of the government, we have a problem. So again, causes rifts between Federalists and Democratic Republicans as a whole. And it showcases a violation of the First Amendment right to freedom of speech. So the amendment and the Great War. Now, you've heard about some of these already within the presentations that your group mates or your peers did regarding the U.S. and the war. And so let's just revisit them. Right. In June of 1917, you have the Espionage Act. In May of 1918, you have the Sedition Act. The focus will be primarily on the Sedition Act. Basically, if you interfere with the war effort, you're subject to jail and fines. During this time, there are over 2,000 persecutions violating these acts, right? And they can be pretty loosely based. It could be because you might have been of German descent. It could be because you weren't too keen on the draft. It can be because you were just unsure of what the U.S. should do or would do in the war. If any of those come up, you can be subject to fines and jail time. And it aims to silence any dissenters of government activity and nationalism. So the case that we focus on here primarily is Schenck v. United States in 1919. The facts of the case. Schenck is a member of the U.S. Socialist Party. He distributes leaflets against the Selective Service Act, right, the draft for World War I. And he compares conscription or service to slavery, basically saying, look, stand up and defend your rights. He's arrested and convicted for violating the Espionage Act and in turn the Sedition Act and sentenced to prison. He argues that his First Amendment right to free speech is violated. So, the question of the case is, did Schenck's conviction under the Espionage Act for criticizing the draft violate his First Amendment right to freedom of speech? The holding is no, it didn't, in a unanimous decision authored by Justice Oliver Wendell Holmes. The decision here says that the Espionage Act is appropriate as an action, right, an exercised action under Congress's wartime authority, Significance of this case being the court rules that the deference or submission to the government is greater in times of war. If the government wants to do something, bring in an act, right, institute a policy, whatever it is, during a time of war for the benefit of the nation, that is allowed. And no law, no amendment really can supersede that. In this case ruling, we have the first assertion of a clear and present danger test. Basically, this means, right, does the action present a danger to the United States as a whole, right, against national security, you could even say. So the actions by Schenck, according to Holmes and the Supreme Court, provide a clear and present danger of a significant evil that Congress can prevent through these acts by saying, look, don't go for the draft, by comparing it to slavery, by saying that people should exercise their freedoms and their rights. You are preventing the United States from protecting itself in this war. And so, in turn, the court rules in favor of the laws or the acts over the rights of Schenck. Also, this is where we get the saying that, you can't shout fire in a crowded theater because, one, that free speech is not protected. It provides a clear and present danger. You shout fire in a crowded building, right? Let's say we have a fire drill going on, or not a fire drill rather, but let's say there is a fire that is set in a building. There are 100 of us in there, and maybe that fire can be stopped. Maybe it's small. Maybe there's no fire. And I decide to shout fire. Your immediate reaction is to get out. Your immediate reaction is to do whatever you can to save your own skin, and that is justifiable, of course, but it provides a clear and present danger. There's a safer way and a better way of doing that, maybe by even not shouting fire in a crowded theater. And so, again, the court is saying, look, by Schenck's speaking out against this draft, it is presenting a danger to the United States. And it is in this case, as with what we saw with the Alien Sedition Acts previously, that we see that the right to free speech is not without limits. So we have 3 additional cases that come around World War I regarding First Amendment free speech. Debs v. United States, 1919. Eugene Debs is convicted for speaking out against the war, and his conviction is unanimously upheld. Again, same standards applied as in the Schenck case. Frowork v. United States in 1919. Jacob Frowork is convicted for criticizing the U.S. involvement in World War I in a German-language newspaper. So already he is at a disadvantage, right? The country is already pretty much targeting those of German and Austro-Hungarian descent. This does not do Frowork any justice, and so that compounds matters for him. Again, unanimous conviction upheld. Interestingly enough, in the Abrams v. United States case, the defendant is convicted for distributing leaflets speaking out against U.S. involvement in Russia to put down the revolution and in World War I. And the conviction is upheld 7-2, except this time Holmes, the same guy who authored that decision, actually who authored the decision in these 2 previous cases plus Schenck, is dissenting, because here he says, well, it's not a clear and present danger. It's just against U.S. policy that this individual does not agree with. Abrams, right, still convicted 7-2. So the First Amendment has continued to be challenged, and we can talk about how it's challenged in different areas, whether it's assembly, petition, religion, press. There are numerous examples. But for freedom of speech, we enter into a realm of symbolic speech as we go further into the 1900s. Symbolic speech meaning obviously not necessarily spoken. And there are 3 cases that stand out. The first is United States v. O'Brien in 1968. This is in opposition to the Vietnam War, where you have David O'Brien basically decides to burn his draft card. He's from Boston. He burns his draft card. He is arrested, right? He is convicted. He appeals this decision, and he appeals it to the Supreme Court. The Supreme Court rules in favor of O'Brien's protected free speech. Basically, it says the court states that we have to find a narrowly tailored interest for the government. Basically, does the government's interest is that substantially outweigh the rights and freedoms of the people? In this case, no. O'Brien had or was within his rights to burn his draft card. Tinker v. Des Moines High School or Des Moines School District basically had Mary Beth Tinker and her brother decide to wear armbands that have a peace sign on it. Again, during the Vietnam War, they are sent home. Right, they are threatened with expulsion. They appeal this decision, again showing that symbolic speech is and can be protected. And then lastly, we have Texas v. Johnson in 1989, in which Gregory Lee Johnson decides to burn the United States flag in a Dallas, kind of like a city hall area. He burns the flag, and it is a measure of symbolic speech against Reagan-era policies. The court actually, in this case, rules very narrowly, 5-4, in favor of Johnson, saying that it's protected speech. Right, this causes an outroar, obviously, and policies and amendments were attempted to be written to protect the desecration of the flag. Obviously, that did not happen. We do not have an amendment on that, and it is still ruled as protected speech, despite the fact that it is obviously looked down upon. So that'll bring us to the end of this, but again, I want us to be able to see and understand that free speech, First Amendment rights, and really, again, you can pinpoint some of the other rights within the Bill of Rights, are not 100% protected. They're not flawless, right? There are areas and periods of time where free speech is not a protected right if it is against, you could say, the will of the country, right? If it presents a clear and present danger. And so understanding the Schenck case is incredibly vital to understanding where the Supreme Court starts to go, where cases start to go, and how speech is then interpreted, both verbal and symbolic, going forward in the history of the United States.